is a topic that applies to everyone. If you've ever bought a ticket to go on a ride at an exhibition, or if you've ever gone bungee jumping, skiing, the list goes on and on, horseback riding, you've probably had to sign a waiver. And you say that there are ins and outs of waivers and a lot we should actually know.
Right. Well, Leanne, we've discussed waivers before, and the waiver, that's right. That's that form that you sign that if you go to do an activity that you tell the people that are providing the activity that you're not going to sue them if you get hurt, or sometimes you click a box if you're doing it online. And, you know, when we've talked about waivers in the past, I'm going to say the last 10, 15 years, the trend was essentially you sign a waiver, you're kind of stuck with it. But there have been some recent cases that are changing that a little bit. And one of them in particular was a case where there's a season ticket holder at Blue Mountain, and as part of buying the season ticket, he signed a waiver that if he got hurt, he wasn't going to sue. Sure enough, he gets hurt skiing and decides to sue anyway. And the courts, in looking at the strict waiver that he signed, said, well, it's fine that there's a waiver there, but there's also something called the Consumer Protection Act. And the Consumer Protection Act says that you cannot contract out of your obligation to provide reasonably acceptable quality services. So you can't hide behind a signature and then provide subpar services to somebody.
So he had faulty equipment?
There was, what it was I think that there was debris left on the ski hill. So I think there was a broken ski pole or something that hadn't been cleaned up in time, and he skied over it and hurt himself. So it wasn't the equipment, it was the hill itself had something that was dangerous about it. And so what that is it's a departure from what had been the case where if you sign something, you're sort of stuck with it. The courts are also moving more towards looking at these waivers and saying, well, is that really what was being contemplated in the waiver? So there was a police federation college case where somebody was, they signed a waiver saying, you know, if I get hurt, I'm not going to sue, but he was running and a basketball rim hit him in the head. And the court said, well, that wasn't what was being contemplated. What we were talking about is if you're doing hand-to-hand combat and you get a bloody nose, you can't sue. So they're really narrowing the scope of how they're going to enforce them.
And more of a case-by-case basis, I guess, and you're a personal injury lawyer,
right.
So that's what you look at. But here's the question for you. You travel, right. You have kids, you do fun things. But do you sign the waiver?
Yep. I mean, really, you're not given much choice. You sign the waiver, and there are certain activities that have inherent risks, and I think most of us are prepared to assume the inherent risks in an activity. It's when the location fails to meet a reasonable standard is when it gets a little dicey, and you should consider. Don't just think because you signed something that it's over.
Okay.
If there's something really unsafe, then explore your options.